Everyone, welcome back to the channel. My name is Varun Kaushal and I'm a legal intern at LEXIS and Company. Today I'm going to discuss about role of NGOs. The law and the society are being in a unique relationship since the formation of the two both act as in a symbiotic relationship, acting as the cause and effect of changes in one another. But with changing times and needs, both undergo changes. Though the changes in both are made with a common object, the peculiarities of both the law and the society make them divergent to each other. NGOs, which find their own existence through Societies Registration Act 1860, however, can solve the problem of convergence of the law and society. NGOs tend to function mainly at grassroots level of any social or economical cause which is directly or indirectly impacting the society. NGOs not only work for spreading awareness but also for the benign motive of changing the society. For that purpose, the NGOs may start various initiatives and campaigns. Therefore, acting as a social catalyst, these activities, though have a major impact on the lives of the people and the society, the role of NGOs, as have been described under the Act, has ignored a crucial responsibility to be performed by the NGOs, which is to bridge the gap between the law and the society. In this video, it is argued that although the expectations from the NGOs has been limited only to social work and social reforms, the big picture comprises of the greater responsibility on the shoulders of the NGOs to make laws and society compatible. What is the need for converging law and society? Law, if seen from a sociological approach, is the general conditions of human activity prescribed by the state. The law is majorly influenced by the values prevalent in the society and therefore is governed by the social values and norms. The law, when seen from a sociological perspective, is itself a part of the society and the social values which the society has evolved within themselves to control and coordinate their efforts and desires. However, with large differences within the society itself, the process of lawmaking became a difficult task which was surrendered to the state of maintaining society's well-being. With state having the new lawmaking powers, there arose the difference between the social norms and law, which is strictly enforced by the state. But with this difference, there arose distinct peculiarities of both law and society, due to which the sacred relationship between the law and the society suffered a serious blow, which made the law and the society divergent to each other. Law, on one hand, is much more codified and complex, which is binding upon the people by the state. Social norms became an informal set of rules which are implied in everyday life. However, law requires much more deliberation and consideration to be formed and enacted. This cumbersome process makes law incapable of serving to the needs of the society at the right time, leading to incompatibility between law and society. The incompatibility may have severe repercussions on the society, which may rather increase the crime rates in the society and lose the control over the people. Also, incompatibility can also lead to difficulty in enacting and enforcing law in the society, which is not ready for the changes brought by the law. However, the belief that the enactment of the law should wait for the society's approval is completely a wrong notion. The relationship between the law and the society is not only influenced by the society alone, but also the law is seen many times influencing the society. Law, though is a state instrument, yet it is capable to bring social reforms and changes to positively impact the society. This point was also furthered by the Supreme Court in Joseph Shine versus Union of India, where it cleared its intentions as a judicial body and through its powers granted under Article 142 of the Constitution. The tension created due to incompatibility between the behavior desired by the law and the behavior approved by the society will not only harm the structure of the society but also make the enforcement of the law difficult. Therefore, the need for compatibility between the law and the society seems to be obvious in this situation. The need of the converging law and society was also highlighted in the judgment of Justice Bhagwati, where he furthered the point of law moving not backward but with the society, where will make the society controllable and coordinated with better measures. Role of NGOs in linking law and society. At present, the NGOs are commonly recognized as the agencies of social work, which instead of having profitable motives, initiates to work for the betterment of the society. However, an NGO is much more than that. NGO, which stands for non-government organization, itself clarifies its roles and responsibilities. They can be called as the non-state actors who have the same object as of the state towards the betterment of the society, but aim to provide better services than provided by the state. NGOs mostly function at the grassroots level, directly providing services to the needy and unprivileged under its programs and social initiatives. With their mass campaigns, social drives, and programs, the NGOs are capable of leave a deep imprint in the minds of the people, thus changing their behavior and mindset. The NGOs can contribute in many social issues which need to get more attention than it is currently getting, like education, environment, health, human rights, etc. Moreover, the NGOs act as a social mobilizers, which also help in spreading awareness in people and mobilize them towards a social cause. The quality of the NGOs to act as social mobilizers is often helpful for the government, through which policy awareness and uniting people for a cause is much easily done by the NGOs than by the state. In the relationship between the law and the society, NGOs can therefore act as a connection between them, thereby linking them. NGOs which remain in constant attachment with the society will be much helpful by making society cognizant about the laws enacted. The way forward. Though it is so far impossible to make law and society perfectly compatible to each other, still NGOs shall play a major role in making them compatible. These changes in the law and the society would have to be parallel to each other to enforce laws in the society in a more efficient manner. Many NGOs like Brahmo Samaj have previously achieved this great feat of convincing society, change in norms, and have worked towards building a better society with effectively helping the state in enforcing the sustainable laws to catalyze long-lasting social changes. NGOs may be called the social catalysts and social mobilizers, but as pointed out earlier in this video, in the bigger context, NGOs share a much bigger responsibility intrinsically to act as a bridge between the law and the society. That's it for today's video. Thank you for watching. If you guys have any questions regarding the video, please do ask in the comment section, and don't forget to like, share and subscribe the channel LEXCLIQ.